So, for our final breakout session, we have, from little statements, great problems grow. This session focuses on using business system level collaborative practice with lawyers and other professionals to improve financial representation and management outcomes for clients and improve professional and ethical accountability between client, their representatives and advisors. Some of the issues that may arise will be highlighted by a description of the differing laws relating to the powers of attorney throughout the country. So let me now introduce you to Michael Perkins and Bernie Walrup. So Michael Perkins is a trust and estates lawyer who has practiced in private wealth advisory for over 40 years. He is the co-author of the estate planning text with Robert Monahan, now in its 5th edition. He is a member of the Conduct Review Commission of Financial Planning Association for 7 years. He's the designer of the education pathway that supported the Accredited Estate Planning Strategist designation for the FPA. He's also a current Designation Committee of FAAA member and is engaged with the Financial Planning Standards Board in updating its global texts about estate planning and in compliance. Michael is also the first private practice lawyer in Australia to be accredited as a member of the Institute of Collaborative Working, having successfully completed its foundation skills course in business system level collaboration. He's also got a TEP designation from the Society of Trusts and Estate Planners. Bernie Walrup, is an Adelaide barrister practicing primarily in the areas of tax, trusts, estates and valuation matters. He's been in legal practice for nearly 50 years. No, I don't believe that. No. And during most of that time, he has practiced in those areas and as a commercial solicitor involved in a number of significant commercial projects in South Australia. Bernie also serves and has served on various taxation committees and has been involved in the preparation and presentation of various submissions in respect of taxation laws and practice. Bernie also has academic interest in the use of computing in the law and the laws related to the use of the area. He has presented and published papers both locally and internationally on the matter. Please welcome Michael Perkins and Bernie Walrup.
Thanks very much. And, well, I know we're holding you up from lunch, so we're going to try and canter through as well as we can. If we don't get through the Q&A, Bernie and I will be down at the speakers' corner and very happy to take any questions and, later also. I've been here since Monday and picked up quite a few themes. And I was also very grateful to have had Catherine Hunt and delivering her session on the ethics of risk profiling. So here I am, an estate planning lawyer, sitting in front of a whole group of financial planners saying, what's this issue about collaboration about? Well, collaboration is, for me, a business model choice. And the work we've been doing with Harry Maragos in Melbourne over the last year is putting some meat around the procedural realities of how do you do that. What we need to do is focus on de-risking financial decisions in the context of estates practice. Just as a quick show of hands, how many STEP members do we have in the room? Okay, thanks. If any of you are interested in expanding this area of estates practice as financial planners, the Society of Trust and Estate Practitioners does give you an environment to do that. And we're seeing more and more senior financial planners come in to STEP and and there is an experience qualification pathway into STEP. Well worn, well understood. And very happy to talk to anyone over lunch. So this issue about collaboration, why am I sitting here saying why is collaboration important? Quickly, is anyone having problems dealing with banks and powers of attorney? Right, I rest my case. Now, Bernie's going to take you for a deeper dive on the law and practice of financial planning. We're going to be able to unpack a bit more of that at the end. and you'll come out of here with a deeper understanding of the law of powers of attorney across Australia than you started. But it's really important because client assets can be across any jurisdiction in Australia. Client decision-making, families get strewn around Australia. We need to start understanding power of attorney from a national perspective, not just a state law perspective. That's why you're getting a deeper technical piece on powers of attorney as part of this. The other thing which I'd like to remind everyone, please have a look at the resources section in your app. We have put up there a whole series of resources around the implementation of powers of attorney and formal collaborative working. If I do nothing more in this session than to encourage you to go for a deeper dive on the links and resources in the slides and the resources, I'll be a happy man. So we've had the introductions. The structure is, we're going to cover 5 points. A quick introduction to business system collaboration, a discussion around, is your power of attorney fit for purpose? How can you help me with powers of attorney? How can I help you? That's the essence of the collaboration. Bernie will take us for a deeper dive on powers of attorney, yes, from a legal point of view, but also to understand how far can the authority of a power of attorney go. Then we'll come back into the ethics of service delivery, which takes a slightly different twist to what Catherine did in the prior session. And then we'll be looking at, if we have time, a couple of toothy issues. How many people here use MDAs? Ah, good, okay. Then hopefully we'll be able to set some questions for you to ask the people that think they're such a wonderful thing. They've got a great they can have a great benefit, but there are a couple of stings in the tail. Okay. So collaborative working. This actually, the idea about collaborative working started, believe it or not, in the early 1990s in the building and construction industry in England. They were having problems with quality control in building things like skyscrapers and bridges. What was the problem? There wasn't a uniform standard for how people contributed to the construction of a complex building. Collaborative working started as a tool to help suppliers and professionals working to a common goal work in a way that de-risked the construction of the outcome for the client. Now, in this case, originally it was the building or the bridge or the skyscraper. But think of it in our case, client outcomes. You know, you're financial planners, you're accountable to not only the financial goals of the client, but the personal goals of the client. So in that area of how are you accountable to the personal goals of your client, what's the knowledge you need to actually manage that outcome from the client's point of view? That's where collaboration comes in. I've heard plenty of people this week talk about collaboration with the client. I haven't heard anyone yet talk about collaboration with each other. As financial planning gets more and more specialised, collaboration inside your profession is going to be just as crucial as collaboration with allied professionals and collaboration with the client. What do you need to bring that together? A common vocabulary. There is an ISO standard 44001, which has just released a small business version. Beginning of last year, we have the Institute for Collaborative Working. The references are there on the slide. But the purpose of collaboration is not cooperation, it's not communication, it's not referral. Collaborative working facilitates businesses coming together to co-create and deliver new shared value products and services that meet, in many cases, exceed customer expectations. So how do I, as a lawyer, work more closely with a financial planner that's going to create more value around the client than us just working from our own perspectives? And inevitably, it's the ready achievement of the client's personal goals that provides the source of the value that, yes, you can price. And yes, we can get more, and so we can earn more money and generate empowered, happier clients in the process. So I'm not going to belabor this, but the message here is think of collaboration as a business model choice. In the initial keynotes, one of the messages there is keep things simple. What collaboration as a business discipline teaches us is, look, I think we need to look at this idea of collaboration from the client's point of view. What's the client outcome that we're fulfilling? How do we contribute to that? Who's going to manage that? One thing I have had this week is a lot of people put up their hands and said, I want to be a project manager around this. How do I do it? ISO 44001 in the Institute gives us a vocabulary, a process map, a set of activities and methods that we can use to actually deliver on that. But as I said, it's a business model choice. So here are the core activities you can come back to. Think of a power of attorney as a collaborative engagement. It's not just about dealing with financial matters. Powers of attorney are just as important in the delivery of support for medical services, support for personal goals, not just financial goals. Everything that Catherine said in the last session about risk profiling and understanding the client's psychology for risk and what are they trying to achieve is just as relevant in this context as it is in the investment management context she was talking about. So you need to think about how does your knowledge relate to the outcome sought by the client and the knowledge of other professionals engaged in the job. Because very often we're only dealing with, the creation of a power as a lawyer, how that power gets used and how you mitigate the abuse and coercion risk in the affairs of the client. That's closer to your role. But is it within your business model to assume that responsibility? Values, principles, and purpose. This is the lens we apply to our role. And Catherine's presentation, I think, gave us an interesting sidelight into that. So whose value drives the representation of a power of attorney? The donor, you, the law, the attorney themselves? How is that meant to be understood? As we say to clients, the purpose of the power of attorney is to deliver representation. The principles is essentially the law, and Bernie's going to give you a deeper dive on that. But if you don't understand the values of the client and their expectation and the accountability they want to have between themselves, the representation and care delivery, we've got a problem. There's also a little issue of, does a power of attorney equip you to deal with all financial products and services that you've got the ability to recommend? Is the power of attorney I write fit for your purpose in helping the client manage their financial affairs? If you think that a power of attorney is a license to do what the attorney thinks is right, you've got another thing coming. So, yes, we've got a broad risk landscape. Catherine's session took this out to a far deeper extent than I'm going to even touch on here. But just noting at this stage, collaboration is the method of shaping a professional's knowledge, skill and experience to the client's job to be done. If you want to understand the criticality of that, It started with Clayton Christensen, a academic in the US, and if you put into YouTube, client's job to be done, or the milkshake experiment, you'll see a whole pile of stuff that will be very relevant to this question of why is the understanding the client's job to be done rather than your perception of it so critically important. So, as lawyers, you know, when we're trying to build up this shared vision of work, so, you know, yes, hopefully we've got plenty of readers of Perkins and Monaghan on estate planning in the room, but how do we actually create a service space that more than one professional can inhabit? We need a vocabulary. So the basic vocabulary in this is my job as a lawyer is to help my client deal with their wealth conservation, estate governance, administration, and succession of management and ownership of their estate over time. Now, is there anything in those statements that you can't or won't or don't contribute to? So if the idea is, okay, we now have a common set of a language and a vocabulary, we can talk with the client, understand their objectives, and then take out of those objectives what's relevant for implementation around our particular skills. And the advisor closest to the client is going to have that project management role by default. No need to think about it. Your client will be looking to you as their man of affairs. Now, you come up with FASEA Standard 4. You know, clients informed consent to what? That they understand the strategy you're recommending. How do you evidence the client's understanding of the benefit that they will receive for themselves out of the implementation of your strategy? Different conversation. So understanding the client's job to be done, in my view, is a critical part of understanding the client's, the benefit the client is trying to receive in working with you. Now, so, the subtitle of this, Great Problems from Little Statements Grow. I want a power of attorney. That's a bit like me standing in front of you and saying, I want a statement of advice. Sending a client down the road, oh, get a will, power of attorney and guardianship, and I've done my estate planning. Rubbish. That's 1995 thinking. So, we need to go for a deeper dive. What risk is your client creating or managing with this statement? Again, Bernie will go for a deeper dive on this. Is your power of attorney fit for purpose? This is where the third-party acceptability of powers of attorney and making them fit for purpose is becoming an increasing issue. And second is this issue of accountability between donor and attorney. Where do you think financial abuse and coercion comes from? Basically, it comes from a divergence of values and objectives and a lack of accountability between a person and their representatives, supporters, carers, and family. So shared values is a key mitigation around managing abuse and coercion risk in families. We could spend the rest of the conference just on that. So, core problem, banks are not accepting powers of attorney at face value. This is where I've got a real problem, and there is a major project between the Australian Banking Association and the Law Council of Australia around this. But this dates from 2019. Banks encounter problems with some powers of attorney because they weren't set up to cover different types of transactions. Now, that, as a lawyer, I think that's rubbish. Just sheer, unadulterated rubbish. by legislation, a power of attorney can do anything in standard form, can do anything a person can lawfully authorise someone to do. So we have to understand how we work with banks and deal with this problem. It's not going away, but it starts with having a deeper understanding of the power of attorney in the, and that we will deliver on this morning. So another point of reflection, what does your business model say about your ability to deal with wealth conservation, estate governance, administration and succession? Or are you just instructed to follow RG 146? Yes, you have a difference between client outcomes and financial resources outcomes focused business models. These can inhabit the same business, do they? And what's the purpose of the power of attorney from the client's point of view? What are the risks we're trying to manage? What are the choices we're trying to manage? For those of you in Victoria, there's a whole lot of very well-structured legislation that helps clients through a range of these choices, less so in other jurisdictions. But the important thing here is understanding these issues from the client's point of view. Reflect on, and this comes back to your business model, your licensee, what you're told you can do by your licensee. What is your role as a financial planner in dealing with this? Is it your business model to just send the client down the road? If you're going to say, no, we want a deeper connection with the client, what does your business model and compliance manager actually say about that? This impacts, you know, especially for those in strictly employed roles, a lot you have to worry about. So we'll come back to this later, but you've got 4 modalities of ethical professional practice. 2 of them are on the left side of the brain, 2 of them are on the right side of the brain. If you're serious about collaboration, you need to think, right, what do I have to do to actually collaborate? So here are my top 4 points. You know, if we're going to collaborate, should we simply say, I can only act with the legal and competent instructions of my client? So this is where there's this danger of assuming capacity and needing to understand client competence, not just client ability and client's ability to communicate. I practice the national decision-making principles. What does that mean? It means that you need to respect the will and preference of your client. Your purpose as a professional is to support and safeguard the will and preference of your client. Now, how are you going to do that? Well, third point, the third major point, practice the ethics of care. And we could spend the rest of the day just on that one point. The ethics of care basically is we practice our profession from the client's point of view. We understand risks, relationships, objectives, influences on the client from the client's point of view, then apply our professional knowledge, skill and experience to that in order to then help the client achieve their personal goals, which necessarily include financial goals. Why do we continually pull financial goals and personal goals apart? Hey, I'm the lawyer in the room. So, understanding, are you dealing with a competent client and why? And so, when we're talking with clients about powers of attorney, we're talking about representation. Who's got my talking stick? Who am I connected to, and who's the attorney going to need to work with? Finances. What are the nature of the financial products and services that the attorney is going to have to deal with? And what's the future that I'm trying to create through the administration of my affairs? Clairvoyance is in no one's job description. So with that, I'm going to hand over to Bernie to take you through a deeper dive on this toothsome thing called a power of attorney.
Thank you, Michael. So let's move on. So, as you gathered, I'm a barrister and get lost in technicality. So I'm sorry, we'll take a deep dive. So what is a power? And it's one of the most simple documents you'll see. Quite often these days it simply says, I empower my attorney to do everything I can do personally. So we'll look at what you can do personally, or what an attorney can do, because it doesn't mean that. We'll talk about quickly an enduring power. An enduring power has become an important tool in estate planning. The concept of a power of attorney is that it's an agency concept, and your agent can only do that which you can do. Once you lose capacity, your agent loses capacity, and that's where the EPA comes in. In most jurisdictions, there's little text, some formalities. The formalities are getting more complicated, and it's often a beguiling, simple document, but it does have a lot of authority. An effective power in a federal system, as I'll demonstrate over the next 15 or 20 minutes, is quite a complicated situation, and I'll come back to attempts to reform that. But we have a highly mobile population. Quite often parents live in one jurisdiction, children in another, and you've got assets in a third or fourth. So you really do need to understand the complexities. Ultimately, you will pass it back to a lawyer, but you need to know what to tell the lawyer. So you need to understand, at least at a high enough level, what the issues are. The use of an EPA needs to be considered also, as Michael's already pointed out, if you are going to engage in advice on other instruments which may themselves have another power of attorney embedded in them. And we'll come back to a concept about non-delegation. So this part of the presentation is a brief description, I can assure you it's brief, on the issues and matters that you may need to consider when working with a lawyer and the client in preparing an effective, and I will focus primarily on an EPA, an enduring power of attorney, but I'll very quickly explain the differences. The enduring power of attorney has become the instrument of choice to deal with incapacity. So you do need to have that understanding, and that's where a lot of the focus is going to be. In terms, what is a power of attorney? At its simplest, I quote from a decision, a power of attorney is a formal instrument by which one person empowers another to represent him, sorry about the sexist language, but it's only 20 years old, to represent the person or act in that person's stead for certain purposes. So it's simply an agency concept. And really, the difficulty with this concept is that it came out of the master-servant relationship in the commercial world and developed between the 13th and the 17th centuries in that environment. So it was never intended to do some of the things we now seek to achieve using some forms of powers. So it is primarily developed in a very narrow concept. So remember where these things come from. They quite often explain some of the nuances. One of the leading texts says there's three characteristics. A formal legal document, it affects a relationship between one person and another, or one person and others. And the extent of the relationship is defined by the document. That's possibly an older view. The extent is clearly defined by the document, but it might simply say, this is a general power of attorney. In some states, that is sufficient. In other states, it might say, I authorise the person to do everything I can lawfully do by an attorney. It tells you nothing about what you can actually do. So it might have restrictions. It might have restrictions in the body of the document. Other times the restrictions are to be found in the legislation if you're relying on the legislative basis. As I've said, the law relating to it comes from historic law. It's a concept of agency. Now, what really led me into some of this was looking at a power and what you really can do with a power. And this is a common law. I'll then take you to what you can do under legislation, and at that stage you'll learn that you don't want to go near this stuff. So at common law, an attorney could only do what the instrument said. When I started 50 years ago, we used to have this power of attorney that went in for 50 pages. It used to say you could do just about anything, but everything you could do was laid out in paragraph after paragraph. We did have a short form. A lot of the banks didn't like them. They wouldn't take them. A lot of people wouldn't act on short form powers of attorney. That got reformed by legislation around Australia, and we'll touch on that shortly. So it comes down to express powers. One of the principles of agency law is an agent cannot delegate. So you need to consider that in any grant of power of attorney, and if you are going to then advise, as Michael's pointed out, on financial instruments that in themselves have embedded powers, that power of attorney may need to have the power to delegate. But I won't get into what lawyers can do. I'll keep going. It doesn't cover personal appointments. So if your grantor of the power is on a board, she's on a committee, it doesn't authorise them to do the acts on that committee. There might be a proxy system, there might be various other systems that allow that, but you need to look to the constituent document of the particular organisation. But generally an attorney can't undertake a personal appointment. They can't practice as a solicitor, but solicitors... so I have a grantor who's a lawyer, I appoint an attorney, that attorney can't practice as a lawyer for me, but I do have employees, so at that point it all gets a bit grey. Matters of personal concern. To suggest that an attorney can sign you up for a marriage, a divorce, or adopt a child on your behalf seems a bit odd, but it is covered in all the texts, and as we'll see, the legislation goes even further in some cases. Trustee is an act of is a personal obligation. The South Australian legislation says that a general power of appointment doesn't include the right to act as a trustee. That's what you would expect. So you need to look at whether the trust instrument allows there to be a delegation before you can start looking at whether an attorney can do it. Go back to the trust instrument. Same much with executors, but they've got a different twist. I won't bore you with that. Statutory rights. Generally, they can be done by an agent. So if I empower you to do something on my behalf and a statute says I can sign a lease, then an attorney can usually do that. But every now and again, some statutes are so personal that an attorney can't do it. And personal privileges, I hadn't quite considered this one until I prepared a paper some time ago. And the example was bringing in tobacco into the UK. There are two cases on it. An attorney sought to say, I'm bringing in 200 cigarettes on account of X who's living in the country. They got prosecuted and it was found that they had no authority simply in relying on the attorney. So next time you're coming in duty free, you can't bring in 400 litres of alcohol and say there are 27 people you're bringing it in for. Okay. Wills. An attorney cannot make somebody else's will. You just can't do that. The court can these days, but that's quite complicated. The next one is the most contentious area, one of the most contentious areas. What right does an attorney have to make gifts? And this is the area that, one of the major areas of abuse. Various legislation restrict it, some powers include it, some legislation has limits. It's all over the place. You need to consider it. Litigation, normally an attorney can engage in litigation on behalf of the principal and instruct solicitors. They might not be able to swear the necessary affidavit. So there are sometimes some parts of the process that requires the client rather than the attorney to do the act. Voting, they can't go and vote in the federal election for you. They might help you fill it out at home. If they get caught helping you fill it out in the witness box, in the polling booth, you might end up in a court of disputed returns, where I did 40 years ago. So be careful. In terms of super binding, non-binding or binding death benefit nominations, this is another contentious area. There is a Queensland decision holding that an attorney could, in the case of a self-managed super fund, where the rules provided for the attorney to be able to do it. And so the first thing is, in the case of SMFs, what do the rules provide? What does the power provide? And then watch out whether the attorney has a breach of their fiduciary duty, because if the attorney is nominating themselves, can they use the power for their own benefit? I'm not going to dwell. I could fill up an hour on that topic. Generally, as I said, powers come from master-servant relationship and come from commercial areas. Powers generally do not allow the attorney to deal with matters of health and matters of welfare. Some legislation has now crossed these bounds. The common law position is reasonably simple, but the legislation now sometimes allows attorneys to do some of these things. In this state, we have a separate act dealing with those type of matters. And if you start talking about powers to be used interstate or overseas, there's a whole pile of further issues, because if you want to use the power in a different jurisdiction, you will then have to satisfy quite often the laws of the jurisdiction in which it was granted and executed, and the laws in the jurisdiction where it's going to be used. And if you go offshore, you run into a whole pile of issues about notarial certificates, get it sent to the Consul General to certify that it complies. You don't want to go near it. So generally, they're the limits. They can have a temporal limit. They can have a time limit. One of the classic ones is, I grant to my son the power, a general power of attorney for so long as I'm overseas. It has an indefinite temporal. It can have a definite temporal period. Now, as I've said, there are different forms of power. Really, at the end of the day, they're just an agency relationship. At common law, as I said, when I was a young practitioner, we'd have a 50-page document. It laid out all of the powers. Occasionally we tried to use a simple document that said they can do what I can do, but a lot of banks and bodies did not like that and wouldn't act on it. So that's the difference between general and special powers. A general power is you can do everything. A special power enumerates what you can do. There's another form of general power of attorney, and that's the statutory one. And that's the one that now says that you can do everything that I can do. And if you comply with the form, generally, that person is then authorised to do everything that I can lawfully do through an attorney. In my state, it doesn't tell you what an attorney cannot do. That's why I went through the common law. In some other jurisdictions, it's the same. There are a number of jurisdictions that now have very different acts. An enduring power of attorney, as I've already said, capacity is dependent on the capacity of the grantor. If the grantor doesn't have capacity, then at common law, the attorney has no capacity. However, that's cured by legislation. It says that if you execute an enduring power of attorney and you comply with certain formalities, then even if I lose capacity, my attorney can go on doing what I no longer can do, but what I could have done. The problem with that concept, and I won't bore you with much history, I can bore you with a lot of it, most likely developed around 1940s, 50s in a couple of US states, permeated its way up to Canada, and then found its way to Australia and England. The difficulty is that the concept of a power of attorney contemplates a grantor who is competent to call the attorney's actions into question. Once you have a grantor who no longer has competency, there is nobody to call the account. And that is the problem that we are now seeing in quite significant extent. And if I get time, I'll mention one. Can't promise you I'll get time. So, enduring powers are the instrument of choice in estate planning. In fact, one might say we all need them because we never know if the bus hits us tomorrow, somebody's going to have to act for us. So it might be that the enduring power is really the instrument of choice and the instrument that's required. Now, this is going to be a quick bus tour. I think you might think you're sitting on top of the triple-decker bus by the time I've finished. So as you can see, the jurisdictions don't have much in common. Most jurisdictions have a general power. Most jurisdictions have an enduring power which says the attorney can do everything that the grantor can do. The enduring power for financial purposes. So some jurisdictions have now started to split what attorneys can do. The three jurisdictions that are most notable are Victoria, Queensland and Tasmania, and then I'll add a territory being the ACT, and the Northern Territory is even more schizophrenic, but I won't go there. Recognition of interstate enduring powers. You can see even that's not consistent. Enduring powers may be made by a grantor outside the jurisdiction and have effect in the jurisdiction without any other formalities. That's not consistent. Restrictions. Grantor must be 18 years and over. 4 jurisdictions have that. The others don't say anything about it. The attorney must be over 18 years. You think this is obvious, but it's not so obvious. Not insolvent, not been bankrupt, not a care worker. Do you inquire about the attorney's standing, the relationship? These are some of the problems. Not a health worker. So if your grantor wants to appoint the doctor, the nurse, the carer, in some jurisdictions it's not effective. Not an accommodation health provider, not a service provider. And in some jurisdictions, financial matters can only go to the PT in certain circumstances. Not a corporation other than the public trustee. That's part of the maze. It keeps going. Now, I'm not going to take you through them all. You can see down there, may not consent to making of or a discharge of a substitute parentage order on the grantor's behalf. I start to wonder, I could say what they were smoking when they wrote this stuff. And on it goes, as one of the members here of this audience pointed out, who's been to this part of this presentation before. If you look at the last one, may not consent to electroconvulsive therapy or psychiatric surgery and health care prescribed by regulation. You know, now, who can take this stuff on board? And then we get to how these things end. You think they end normally, a common law, they end by death. EPA is statutory, so they don't end by incapacity. So if you've got an EPA, it can end by reference to its terms. It can end by reference to death, as you'd expect. Some states spell it out. It can terminate on the revocation by the grantor, but the grantor can only revoke it whilst the grantor has capacity. Once the grantor loses capacity, it can't be revoked by the grantor. So then you have courts and tribunals in various states or territories that prescribe how it can come to an end. I won't dwell. Now, this is a topic that I think you need to be alive to because it is attracting a lot of attention, and that is elder abuse. We don't have any information about the extent of it. There's some anecdotal evidence suggesting that 65% of elders suffer some form of financial abuse based on Queensland helpline calls. The estimate is it runs to nearly $2 billion. A lot of it is through the misuse and abuse of powers, particularly enduring powers of attorney. As I said, there's nobody to call the person into question. Ultimately, it becomes the siblings, if there are siblings, to call it what's going on into question. There are various reports. In fact, Standing Attorneys General Committee has finally taken it on board, and a couple of months ago they issued a discussion paper and they're calling for submissions about trying to standardise across Australia powers of attorney and what's required. Like a lot of that, it might take several years if it doesn't take longer. And if you know the history of common legislation in this country, it very quickly gets undermined. So I'll keep moving. There are various proposals to address it. There are a number of other problems in this area that one keeps seeing. One of the things I didn't adequately touch on is a lot of attorneys, particularly where it's one of the children, there are other children interstate, start to feel, I'm not getting any recompense for this. And that's why they then feel that there should be, or they were entitled to help themselves in some way. When you're thinking about appointing children, particularly if there are children interstate overseas and one person ends up with the responsibility, are they to get some form of recompense? Is there to be something in the instrument to start with so that they don't feel, I need to help myself? It happens quite often. The next form is what's sometimes called early inheritance syndrome. Why can't I help myself now? Because I'm going to get it in any event. They're not going to know. The third one I've seen a couple of times, we got brought home in a particular matter. Oh, we don't want to spend the money because otherwise we're going to inherit less. So they put them into the cheap home, they don't want to spend any money, and they're hanging on to it all. I can't believe it, but it does happen. I've got about 2 minutes and I want to bring out one case and then go through some practical issues. There's a New South Wales case of Grant and Grant. It highlights how bad, and I've got to be careful how bad it can appear to get. In Grant and Grant, one of the children, the daughter, was appointed the attorney in about 2011. Over the next 6 years, she managed to help herself for something north of $4 million. The bank account shows about $5.73 million going in and about $5.03 million coming out. She moved her late father before he died around nursing homes, didn't tell the siblings where he was, isolated him, so he couldn't complain to any of them. If you go and read the judgment, it's horrific. Eventually the siblings cottoned on. Just before she got removed, she managed to transfer the last remaining asset, which was the family home, out. He was in a nursing home by this stage, but still had the house. She transferred it to a daughter, and so there was not much left, about $20,000 in the bank account, and at that point there wasn't enough to pay the nursing home fees. When the other siblings got control, they then had to put their hand in their pocket for that. Now, there are 6 sets of proceedings. The daughter who helped herself appearing in all these proceedings herself, it's just, diabolical in terms of costs. But that's how an example of where they're going. So, to finish up, some practical issues. Know the client. Know what they need. Know the attorneys, but watch out. They quite often, the client and the attorney come in to see you. The attorney is driving what's going to happen. There's a conflict. You need to be alive to it. You need to know the assets. You need to know the states and territories of where your grantor is, your attorneys are, your assets are. If you don't, then you can't give the instructions to ensure that the power is adequate to deal with those assets in those other jurisdictions, having regard to that horrible maze, which I quickly... What type of power should you use? There might be situations where you don't want an enduring power. Watch out for the socio-economic and cultural influences. Some cultures, particularly where the widow, maybe Italian, Greek, is very much, and there are many others, I just picked 2, are very dependent on the son, the eldest son. There are these type of socio-economic pressures. You need to understand those and how they're playing out. Be alive to conflicts and fiduciary obligations, as I've mentioned. I've also mentioned the recompense. If that person doesn't think they're getting paid and they're doing the heavy lifting, they then get far more tempted to help themselves. Try and look out for it. Be alive to conflicts, know the powers to be used with, that's the bankers. We've talked about subdelegation, delegation. If you are an advisor who has constant contact, watch out for change in circumstances. Things might change. Watch out, your attorney might start, there might be less money around and it can't be seen where it's going. It depends on your involvement. If you've got a heavy involvement with these clients, then you might be on notice. Watch for the elder abuse. Obviously, if you're sending them down the street, to use Michael's term, you're only having an occasional contact, a lot of this won't be relevant. But if you are managing closely their affairs, you need to watch out. Because I can assure you, if the matter ended up on my desk looking at to give advice, who to go after and who's got the insurance policies, you might be one of them. I'm sorry to say it. All of that can impact. And on that note, I'm sorry to tell you that I might have to give advice contrary to your interests. Thank you.
So, first point of reflection. Probably this whole conference is about asking you to take a broader engagement and a broader interest in the affairs of your client. Hopefully this now falls. There are some warning bells around what we need to do. So, so to try and extend that idea of practical guidance, competence is as much a matter for the client as it is for you. Does the client have the ability to process and use the information that you give them? What are the... it's not just about capacity. Does the client have... Can you safely assume the capacity of the client? That's something that we need to be careful of. Second point of reflection. When's a power of delegation necessary and when it is prohibited? New South Wales is the only jurisdiction in Australia where you can give an attorney the power to delegate their function. In every other state and territory, it's actually prohibited, and that's where Bernie's tables about the ins and outs of powers of attorney across jurisdiction is very important. So consider the managed discretionary account. It's a financial service, it's not a financial product, and it appoints an investment manager on behalf of a person. And it's buried in there is a limited power of attorney from a natural person. So think of this as a matter of managing account ownership. If a private individual is the account owner, and the private individual loses capacity, so you now have an enduring power of attorney, unless they are in New South Wales with power given by the document and subject to the attorney applying all rules, then no problem. But if you're outside New South Wales and you're prohibited from the attorney delegating the power, you've got to think, what happens when a power of attorney is activated? The attorney steps into the shoes of the donor, but carries with them the authority of the document, not the donor. I can't delegate. There's a power of attorney in here. The MDA technically falls over. Now, if there's any HUB24 compliance people in the room? No? Good, okay. Would someone like to explain to me? I'm the dumb lawyer. I'm not the financial service compliance manager. Will someone please explain to me why that limited power of attorney will universally, across Australia, survive the lack of capacity of the account owner? Go down and talk to the guys at HUB24. Please. Well, I've had personal experience with the Explore MDA, and it's problematic. So I'm not trying to create problems when they don't need to be, but from my point of view as a lawyer, this kind of knowledge is absolutely material to whether the power of attorney I write is actually fit for purpose. What we're trying to do is give you a reason. Why should we be working more closely together? Superannuation T-bars, the status of superannuation nominations, the availability or not of child pensions to an estate planning strategy. The list goes on and on and on. So the business case is, hey, we need to be collaborating at a business system level and delivering estate planning services together rather than me just catching a referral and hoping for the best. So I think good practice is around collaborative practice. These are indicators of vulnerability. It's not just about age. So again, these slides are trigger lists and resources for you to use in addition to what's also loaded into the app. The important thing here, and Bernie's touched on the relevance of and the source of powers of attorney coming out of commercial practice. If you've got purely commercial parties as counterparties, say a family business and another commercial counterparty, generally, commercial parties are, or a commercial transaction, the parties are assumed to be able to self-protect. So fiduciary responsibility can become contractual. You can contract out a fiduciary duty in some context. But with a retail client or a personal client, which is really what you're dealing with normally, they can't. So vulnerability can impact the person's ability to give informed consent, to participate, to understand what's going on. So I commend vulnerability as an issue for you to consider when you're looking at the client and saying, right, are they getting this? Do I have an active decision maker in the relationship? So 4 principles we're trying to land on. Respect the will and preference of your donor, including extending to them the dignity of risk. Just because they want to do something that you don't like doesn't mean that it shouldn't happen, provided that they're doing it for a valid purpose. We are in a rights-based decision-making society that is increasing in rigour. So this is coming up continually. I don't like what mum wants to do or dad wants to do. I'm the power of attorney. Can't I just override them? And the simple answer is not necessarily. Because your power of attorney may not yet be enduring. It may be enduring form. And this is where collaboration between donor and representatives becomes really important. That's why we put a capstone of estate governance as the service area which needs attention, where we need help from financial professionals to deliver appropriate governance in terms of the client's affairs. Be confident of the reasons by which you conclude, not assume that you're dealing with a competent client. Autonomy First Lawyers came out of a project with Macquarie University Health to establish a formal evaluation clinic for decision-making ability. All the clinical instruments of that are on our website and available for people to use, but please come and be trained in them. But this question of don't just assume, because you're comfortable with someone's social facade, that they are talking to you in a socially acceptable way, they're answering your questions. Don't forget, probe. If a client says, hey, this must happen, it's your job to ask why. If the client can't explain the reasoning behind the decision, how can you evaluate whether or not there is unconscionable risk or safety concerns? If you can't engage with that support and safeguard discussion, if the client can't talk to you about why they want to do something, maybe you have a capacity problem at that point. So what we're asking for is to think of yourself as a collaborative, cognitive, responsive professional, open to working with others, responsive to the decision-making ability of your client, and engaged with their decision-making process, not yours. And if you're talking to attorneys, trustees, executors, first job that we need to deal with, what are you responsible for? Clairvoyance is in no one's job description. So establishing a reference balance sheet for the client, maintaining that over time, and as part of the regular review of the client. So if the client falls off the perch, you've got a starting point for saying to the representative, right, this is what we've got to manage. Hey, it's just good business. So if you go back to that idea, we're in the business of dealing with wealth conservation. How do we help the client hold on to their stuff? Estate governance and administration, well, here's how we deal with representation, day-to-day management and review, and then succession of management and ownership over time. There's your estate administration plan. It's not just about death, dying, incapacity. It's about helping clients managing the effect of their longevity. For someone retiring in their 60s, it's a 3 to 4 decade run, potentially. It's as significant as planning for retirement, and yet we're not taking that challenge to the client sufficiently, in my view. A retirement, it's like, yeah, we're here to get you to retirement, and then it's over to you. Really? No, you'll have the self-directed clients that'll go, yep, that's right, okay, I'm ready to climb the next mountain. And then you'll have, as I did last week, the business owner who turned around to me and said, well, I don't want to run this business forever. How am I going to manage my children who really don't want to be involved in the business? You know, we're doing this estate planning. Will you stick around and help us with what comes next? That's gold. That's the kind of client now. And there's not an SOA in sight. So where does your license fit? And this is where we come back to this point. Collaboration is a business model choice. Will your licensee actually permit you to do any of the things we're talking about in this session? The Minister did touch on that fleetingly in his comments. Because we started as this collaboration project with the hospital, that QR code takes you to the download page on our website, and it gives you access to all our clinical instruments that we use for capacity assessment and estate planning. People say, Michael, you're giving away your IP. And I'm going, no. What we're doing is demonstrating to the world what's available to help, and quite frankly, it's all there on a Creative Commons 4 license. Go your hardest, but call if we can help. With that, we're now at the Q&A. So there are contact details there for Bernie and myself. And we've got 3 minutes and 58 seconds. So Bernie and I will also be down at the speakers' conference. We've covered a lot of areas. Rather than worrying too much about the iPad, is there anything in your
Had
mind?
one question come through on the app. So the question is, why are some lawyers keeping hold of the EPA and only releasing them to the attorney when evidence is provided as to a lack of competency?
It depends on the terms. Read the document. Is it triggered on the incapacity of the client? It's one of the statutory options for triggering a power of attorney. So it's read the document, read the document, read the document, just like a trust deed. So if it's triggered on incapacity, then you've got the deeper issue of how you're going to prove the incapacity of the client to the satisfaction of the bank and the financial institutions that you're going to use them with. So I've got to be, generally when we're drafting powers of attorney, we draft them with immediate effect, subject to acceptance when there's if the attorney can't look after their affairs, which gives, I think, a cleaner outcome. But you've got to look at that on a case-by-case basis. Any other questions? Yeah.
Just on the estate planning piece, I'm sure a lot of us here go to great efforts to actually labour with the clients and then with their solicitors to actually work out an estate plan, incorporating testamentary trusts and things like this into their will. I've had a situation very recently in the last year where over a period of like a dozen years with a client, we worked through some advanced estate planning and with one recalcitrant son. And effectively what occurred is that with all this advanced planning, death occurred, and then that son challenged the estate. And at the end of the day, with a Gold Coast lawyer present, that Gold Coast lawyer attrited the estate down to the point where all the planning had to be thrown out because otherwise this would be a prolonged action. So I really do question sometimes this challenging of estates, because you can do a whole lot of effort And at the end of the day, you get one good recalcitrant son, and bad recalcitrant son in this case, and a Gold Coast lawyer in this case, and they can just tear it apart.
Okay, well, I'm glad you're not in New South Wales and have National Estate to throw into that mix as well. I think the law can be a very blunt instrument when it comes to things like family provision, let alone in New South Wales. There's actually decided cases that that the mere provision of a testamentary trust is not adequate provision for family provision purposes. However, the judges are changing and the judicial attitude is changing. I don't know, Bernie, if you've got any thoughts on this. We've only got 14 seconds. This is something we can take out. We can take downstairs. But in South Australia, they've just passed a new succession law that says that the intent of the will maker is paramount. That runs counter to what the very case that you're talking about. What that says for the jurisdiction of family provision, well, we know what happened when Joe Bjelke-Petersen in the late 80s demolished death duties. At the moment, I'm sitting here as a succession lawyer going, what the hell, where do we go now?
I'm not going to add much. We can actually break it down. There are three aspects. One is family provision. One is looking for flaws in what's been executed, how it's been put together. And the third attack, quite often we're now seeing, is more about the constructive trust. So if you're acting for rural families and one of the sons stays on the farm, gets a promise, sits there, that's becoming quite a area of challenge. So it's not even challenging the will or seeking for further provision, it's going back to promises, and it's not just the family farm, but they're the common ones that are coming through. So not only do you have to worry about family provision, notional estates, you now need to also consider, was one of the children promised something? Did they act to their detriment? Did they hang around doing the parents' bidding? And then they fall out. Quite often, if you're in business with your children, after a while, they do fall out. And that's when these type of things really come to the fore. And if the elderly parent and the son falls out, you find the farm and then becomes the subject of the dispute. So it's much broader than, I'm sorry to say, than simply the will.
And if you haven't already picked this up downstairs in the exhibition hall off the Fidelity stand, please do so. It's a really interesting research piece. And look at the strategies that are recommended up the back that clients evidently usually demand. And just think how many professionals are actually required to deliver on each of those strategies. So I rest my case on the collaboration point. We're now at 2 minutes and 29 seconds over, so my apologies to the host.
Not a worry. Michael Perkins and Bernie Walright. Thank you very much, guys. Appreciate it.
Thank you.